Nadja, are there any exceptions to the confidentiality principles you talked about?
Yes, some of them we've dealt with already, and they vary from country to country. But essentially, they cover things like if somebody wants to enforce their mediated settlement agreement or challenge it. We talked about that already, and needs, in order to do that, to bring evidence about what was said or done in mediation. That's typically an exception. If someone wants to bring an action against their mediator, again, a very rare occurrence, that is typically an exception. In some countries, you will need to get leave of the court in order to action exceptions like that. In Hong Kong, for example, that's the case. But there are also other exceptions. For example, if as a mediator you think that the well-being of a child is in jeopardy, you might have a reporting duty. Right? Or at least, if not a duty, the ability to breach confidentiality, to let the appropriate authorities know, and also if you think that someone's life or liberty is in danger, whether it's a child or an adult. So so there are some very typical exceptions. Also, if the parties agree that a particular document or a particular statement can be admissible in court, for example, or need not be confidential generally, then provided that anyone else involved in that statement or that document agrees, and that's also an exception. So, for example, again, the rule varies a little bit, but typically if the parties, for example, want to admit the statement of a mediator, the mediator also needs to agree. If the parties want to admit in evidence a report done by an expert that was prepared for the mediation, the expert may also need to agree if some of the other exceptions sort of aren't present. So there's some of the general exceptions.